I watch smart workers lose leverage with one rush signature all the time. So in this video, I'll walk you through 7 work documents you should never sign on the spot. I'll explain why each one creates risk, and I'll give you the exact words that buy you time and protect your rights. So stick around. This isn't legal advice. I am an employment lawyer in Washington State, but this video is for education. Your situation is unique, so talk to a lawyer in your area for specific legal advice. Okay, let's get into it. Document number 1, arbitration agreements. You might see this during an onboarding or a policy update. HR calls it standard paperwork. Here is the trap. Signing an arbitration agreement means you give up your right to sue your employer in court. Instead, any future dispute like a wrongful termination claim or a discrimination claim is handled by a private decision maker called an arbitrator. Think of it as hiring a private judge. Employers push these because the system is tilted in their favor. The proceedings are confidential, so bad company behavior stays out of the public eye. You often waive your right to a jury trial, the rules for gathering evidence are limited, and your ability to appeal a bad decision is almost non-existent. So if you're facing an arbitration agreement, here is what to say instead. I will review this and get back to you by date. Ask if the agreement includes an opt-out window. Many of them do. And if it does, calendar that date and make sure to opt out in writing before it expires. And if they pressure you, go ahead and sign it, but next to your signature, write the following: received, under review, I do not agree to arbitration. This creates a record that you did not consent, which can be crucial later on. Document number 2 is non-compete and non-solicitation agreements. A non-compete restricts you from working for a competitor for a certain period of time in a specific geographic area after you leave and sometimes while you're still working there. A non-solicit prevents you from contacting former clients or coworkers to bring them to your new company. And here is the trap. Vague language turns a narrow restriction into a career blocker. Watch out for phrases like any business similar to ours, any client the company has ever had, or definitions of confidential information so broad they include the general skills and knowledge you need to do your job. You could be accidentally signing away your right to work in your own industry. So if you're facing a non-compete or a non-solicitation, say this instead: I need time to review the scope, geography, and duration of these restrictions. Then negotiate. Ask them to narrow the territory, shorten the timeline, and define exactly which clients are off limits. If they want to restrict your future, ask them to pay for it, either through severance or garden leave, where they pay you during the non-compete period. And here's a special note for Washington residents. Washington State has specific laws that make non-competes unenforceable for lower earning workers and places limits on their duration. For example, Washington law currently makes non-compete agreements illegal if a worker is making less than a certain amount of money per year, and that number is adjusted annually. If you are in Washington State and your employer has given you a non-compete to sign, contact a lawyer as soon as possible to see if it's illegal. Most of them are. And feel free to call my office if you are in this situation. A link to my website is in the description. Document number 3, severance agreements. A severance agreement is a contract. The company offers you money and in exchange, you give up your right to sue them. This is called a release of claims. And here is the trap in severance agreements. You are giving up potentially valuable legal claims for discrimination, for unpaid wages, for wrongful termination, and the like, for what might be a very small amount of money in comparison to what you could get if you actually went through with a lawsuit. These agreements also hide other sharp terms like confidentiality clauses that prevent you from talking about your experience and non-disparagement clauses that stop you from saying anything negative about the company, even if it's true. So here is what to say instead. I appreciate the offer. I will review this and respond by date. You have leverage here. By law, if you're over 40, the company must give you at least 21 days to consider the agreement and 7 days to revoke your signature after signing. Use that time to negotiate for more money, a neutral reference, or changes to the restrictive language. To learn exactly how to approach that conversation, watch my video, Severance Pay Negotiations, Don't Settle for Less Than You Deserve. I will leave a link to that video in the description. Document number 4 is a resignation in lieu of termination. And a manager might present this to you as a favor, saying, let's part ways amicably, it'll look better for you. But here's the thing, it rarely helps you. When you sign such a document, you often lose your eligibility for unemployment benefits. And you also give the company a clean and simple rebuttal for claims of wrongful termination when they can just say you quit. This strips you of the leverage you would have in a wrongful termination case. They are asking you to do their dirty work for them. Here is what to say instead. If the company is ending my employment, I need that decision in writing. I will not be resigning today. Then stop talking. Don't get drawn into an argument. If they threaten to give you a bad reference, ask for their neutral reference policy in writing. And here's a pro tip. Follow up immediately from that conversation with an email to HR. To confirm our conversation today, manager's name, asked me to resign and I declined. If my employment is being terminated, please provide that information in writing. Now this creates a clean, time-stamped record of what really happened. Document number 5, a PIP acknowledgement. A performance improvement plan, also known as a PIP, looks like a tool to help you succeed, but often it's just the final step in the paper trail to justify firing you. Here is the trap. The signature line is designed to look like you're just acknowledging you received the document, but often the fine print says you also agree with the facts or acknowledge that you performed poorly. Signing that is like signing a confession. That admission will be used against you to deny unemployment benefits or to defeat a future lawsuit. Next to your signature, write, acknowledging receipt only, I disagree with the statements and conclusions herein and will provide a formal response. Then, submit a short and factual rebuttal. Stick to dates, metrics, and evidence. Point out where you lacked training, tools, or support that was promised. Document number 6, disciplinary write-ups. This is very similar to the PIP trap. You will feel intense pressure to just sign the form so you can leave the room. But here is the trap. The write-up may include pre-written lines like, I accept responsibility for my actions, or I admit I violated company policy. If you sign that as is, you've handed the company a legally binding admission and the perfect justification to fire you. Here is what to write and say instead. Just like with the PIP, write receipt only, I disagree with this write-up as stated and will be providing a rebuttal. Keep your rebuttal to one page. Use timestamps, reference emails, and name witnesses. Avoid emotion. Stick to the objective facts. Crafting a strong factual rebuttal is a critical skill. I walk you through the entire process step by step in my video, How to Handle Write-Ups at Work. I'll leave a link to that video in the description of this one. If they refuse to let you add notes or attach a rebuttal, say, then I will email my rebuttal for my personnel file. Send it to HR and your manager immediately with the subject line, rebuttal to disciplinary action, and include the date. You ensure your side of the story is on the record. And finally, document number 7 is a broad medical release or investigation authorization. You might see these if you request a medical accommodation or if you're involved in a workplace investigation. Here is the trap. These forms are often intentionally overbroad. A medical release might let the company access your entire medical history from any doctor for any time period. For an accommodation, they only need to know your work-related limitations. And an investigation authorization might allow them to conduct a sweeping search of your personal devices or social media. So here is what you say instead. I can provide a more targeted authorization. For medical issues, ask your doctor to write a letter describing only your functional limitations at work, what you can and cannot do. For an investigation, you can offer to provide specific relevant documents yourself rather than signing a blank check for them to search your life. You control the scope of the information they get. So how do you protect yourself? You slow down and you control the record. Number 1, never sign anything on the spot. Always say, I'll review this and get back to you. Number 2, add clarifying language like receipt only whenever a signature is forced. Number 3, correct the record in writing with a factual rebuttal whenever possible. Number 4, narrow any authorization to the minimum scope necessary. Number 5, preserve your leverage. Don't resign under pressure, don't admit to facts you dispute, and don't sign away your legal rights for nothing. This isn't about being difficult, it's about being strategic. You protect your career when you control your signature. And if HR asks you to sign something this week, drop a comment with the type of document with no names and no confidential details, of course. I'll pin a top Q&A and update the checklist. You can grab my free one-page Don't Sign at Work checklist in the description below. For next steps, watch my videos on how to handle write-ups at work and severance pay negotiation. And if you found this video helpful, give it a like and subscribe. I make videos that empower workers with knowledge. The more we hold employers accountable for their wrongdoing, the more we stand up for other workers. That's all for me this week. See you next time.